Hi, this is Dan Smith, and welcome to today's episode of Einstein's Theory of Taxability. I'm your host, and today I'm going to be talking about what happens when you get to the end of your IRS audit and you cannot come to an agreement with the IRS about the proposed adjustments that they want to make to your tax return. So you've gone through your audit. Hopefully you've worked with your professional tax advisor, whether it's a tax attorney or your CPA or perhaps even an enrolled agent, and you've gotten to the end of your audit and maybe some issues have been resolved in your favor, maybe some you've agreed to concede, but at the end of the day you get your proposed adjustments and you get the report from the revenue agent, and lo and behold, what you were hoping for did not come to pass, and so you're not happy with the result of the audit. You don't want to agree to the proposed adjustments that the IRS wants to make to your tax return. What do you do? Well, what you do is you file a protest, a written protest with the IRS. And by filing your written protest with the IRS within the time limits, typically what you're given is a 30-day letter at the end of your audit, which gives you basically 30 days to file your written protest. If you file your written protest and you follow all the procedural requirements, which will be spelled out in the 30-day letter, and then also in publication 5 that the IRS will provide you at the end of the audit, if you follow all the procedural requirements, your case will be moved from the revenue agent or the exam level of the IRS to an appeals officer at the IRS and the appeals function of the IRS. Essentially, the appeals function or the appeals office at the IRS is a separate division, separate function from the examination function of the IRS. And so you'll have a fresh set of eyes looking at your case. It won't be the revenue agent that you have been dealing with during the audit. It will be an appeals officer. And when you go to appeals, when you file your written protest, what you typically want to do is to spell out all the facts of your case. You want to put the best light on the facts of your case as possible. Be persuasive in the facts. Of course, the facts are the facts, but you want to put the best possible persuasive light on the facts of your case. You want to spell out any law, explain any law that applies to your case, and be persuasive with that as well. Essentially, a protest is very similar to a legal brief, where in a court case where a lawyer would make an argument on behalf of a client for why that client's position is correct and why the position of the other party, in this case the IRS, is incorrect. When your case gets to the appeals office, the appeals officer will hold a appeal hearing. Typically, these days, most appeal hearings are done by phone. You can request to have an in-person appeals conference, and I would always recommend, if possible, that you have an in-person appeals conference with the IRS. It always is better, I think, to be able to sit across the table face-to-face with the appeals officer to make your case as persuasively as possible. Now, when I say you make the case, it's always, in my opinion, better if you have your your tax professional, handle your appeal for you. This may be the same person who handled your audit, or it may be that you hire someone new and fresh to handle your appeal. In my opinion, you're better off having typically an attorney prepare your protest, because attorneys Generally, especially tax attorneys, people who are used to dealing with tax issues, are more experienced perhaps or adept at making arguments in a legal way, making persuasive written arguments like you would do in a protest than perhaps a CPA or an enrolled agent might be. But again, that's my own personal opinion, my own personal bias. I think that an attorney who's experienced and used to dealing with tax issues can make a stronger case with the appeals officer and then with the appeals office than perhaps someone who is not an attorney and is not perhaps used to writing persuasive legal brief-like materials. So you have your appeals conference, your representative, let's assume it's a tax attorney, will make the case for you, answer questions from the appeals officer. The appeals officer may ask for additional information, more argument, more submissions. It's a process. At the end of the day, the appeals officer will make a decision based on his or her view of the strength of your case. And what the appeals office does, there's the clock. We'll wait for that to ring and we'll go on from there. I should have turned that clock off before I started the video, but that's okay. This is real life. What the appeals officer does is make a determination based on what are called hazards of litigation. And what that essentially means is the appeals officer weighs the facts and the law, looks at your case, and determines whether there's some substantial risk to the IRS that it might lose or it might have a bad precedent set if it goes to court in your case. And so rather than go to court, take the chances of actually losing the case from the perspective of the IRS, or maybe having a bad precedent set in a court case that would not be something the IRS would want to have out there for future cases, the appeals officer will often offer a settlement to you. And typically the settlements that are offered by the appeals office are better than what you would normally get from the exam function and the revenue agent. It's not to say that you might not have an appeals conference, an appeals officer who totally agrees with the IRS exam function or the revenue agent and doesn't give you any better deal or proposed settlement than the revenue agent did. That's entirely possible, but in my experience, I believe that for the most part, most taxpayers, when they go to the appeals office, tend to get a better settlement offer from the IRS than they have received already from the revenue agent. Be that as it may, if you do get a decision from the appeals officer that you don't like, you don't agree with, you don't want to settle, you have the option to just turn that down. And if you do that, then the IRS will issue the taxpayer what's called a 90-day letter. The 90-day letter, like the name says, gives you essentially 90 days to file a petition with the U.S. tax court to take your case up to the next level of appeal. Essentially, you would be seeking to have the U.S. tax court hear your case and make a determination about your position versus the IRS position. Now, when you do get a 90-day letter, it's also called a statutory notice or a stat notice. When you get that, you have to be very, very careful not to miss the 90-day deadline because it is a jurisdictional issue with respect to your case and with respect to your petition to the tax court. That only means that if you do miss the 90-day period to file your petition with the tax court, you're out of luck. You cannot petition the tax court after your 90 days has run. And if you let the 90 days run and you haven't filed your petition in a proper manner, then the IRS will simply assess the tax against you, and then you will be dealing with the IRS as a collecting agent trying to collect the tax from you. So And in short and in summary, if you have an audit, it doesn't go well, doesn't go to your liking, you can appeal that decision of the revenue agent to the appeals office. You have 30 days to appeal that decision typically, and you need to file a written protest. If you are not happy with the decision at the appeals office and the appeals officer, you can go to the next level, which is the U.S. tax court. There are also other courts you could go to, but the tax court is what generally taxpayers go to because it does not require the taxpayer to pay the tax in order to go to the next level. If you want to go to federal district court, you can pay the tax in full and then seek a refund and go to the district court. But if you don't want to have to pay the tax on the front end, if you're not in agreement with the appeals office, you're going to need to file your petition with the tax court within that 90-day period. Okay, if you have any questions, please feel free to get in touch. I'm Dan Smith at DPS Legal Counsel. I work to protect businesses and practices, healthcare practices, from the problems that generally arise for businesses and healthcare practices, which could be tax issues, trademark issues, contract issues. So if you have a question or you want to get in touch, please feel free to call me, and we'll talk to you next time on Einstein's theory of taxability. Thanks.